Hello everyone, my name is Justine Peeler and I am very pleased to welcome you all to this Zoom webinar hosted by the Oxford Law Faculty and its Helix Research Group. So this is the second seminar of our Law and Emerging Technologies Invited Speaker Series this term on the theme of information governance. And we are delighted to have our two speakers today, Dr. Edward Dove and Ruby Reid Berendt from the University of Edinburgh, whose title is UK Reach, Exploring the Legal and Ethical Implications of Linking Healthcare, Employment and Registration Data of UK healthcare workers during the COVID-19 pandemic. So we have planned a 20-25 minute presentation or thereabouts from Ted and Ruby, followed by general discussion. So please, to all of you, do make a note of any questions that you have or comments for our speakers during the presentation so that you can raise them for discussion afterwards. Now, as I've said, we are recording this seminar. Both the presentation and the discussion will be recorded, and we'll be making the recording available to stream from the Helix and faculty websites. So Ted and Ruby, over to you both.
Thanks, Justine. I'm just going to share my screen to get the slides up, so hopefully that will come through nice and easy.
Maybe while Ruby's getting the slide shared, I might thank all of you for tuning in at 5 p.m. on a Wednesday. No doubt it's the end of the day. I suspect many are tired, and obviously if you've already poured the glass of wine or the beer, I salute you for doing so, and hopefully we'll have some interesting discussion. But thank you for tuning in at the end of a long work day.
Brilliant. So hopefully that's come up now. So as Justine's outlined already, today we'll be talking about UK Reach, which is a project that Ted and I are currently working on, and in particular exploring the legal and ethical implications of doing data linkage where the data concern healthcare, employment and registration data of healthcare workers during COVID. So just to give you a brief overview of what we're going to talk about today, first of all, we'll give you an idea of what UK Reach is all about as a project, the various work packages and the kind of data. We'll talk secondly about the legal framework for use of that data and management of it and the issues that arise in law. And thirdly, an ethical approach to data management and why we think that's needed in this context, and concluding with some recommendations for the project. So this is based off a policy report essentially that we've been developing. I'm going to hand over to Ted, first of all, to talk you all through a little bit through UK Reach and what it's all about.
Thanks, Ruby. So just to provide a bit of background, the UK Reach is planned to be a 12-month project funded by UK Research and Innovation, the National Institute of Health Research, as well as the MRC, and support from the University of Leicester. And it's led by PI based at University of Leicester, who I think many of you are aware have been doing some great research anyway on the impact of COVID-19 on healthcare workers. There's some other funded projects that they've been working on. But this particular project focuses on an issue that I think has been, I suppose, as I was going to say, discovered, unpacked at a beginning level, but it's certainly an issue of concern, not just in the UK, but in other countries. And that's namely this concern that healthcare workers, particularly from ethnic minority groups, are disproportionately affected by COVID-19 in different sorts of ways, not just potentially in terms of contracting the virus themselves, but other sorts of direct and indirect and incidental effects. And so in collaboration with the General Medical Council, the General Dental Council, the Nursing and Midwifery Councils, and various professional bodies and associations and Royal Colleges, what UK Reach seeks to do over this 12-month period is to undertake a mixed method study to investigate if, how, and why ethnicity affects COVID-19 clinical outcomes in healthcare workers. And by mixed methods, what I mean then is that it's not only a study that looks at that particular effect alone, but thinks about larger kind of structural issues at play, legal and ethical issues at play, to try to provide a deeper and broader understanding as to what is going on with this pandemic and its impact on healthcare workers. And to that end, just to very briefly talk about the 5 work packages planned for this project. Work package 1 is a big one, and that is the project, or the work package rather, that is undertaking the expedited linkage an analysis of anonymized registration, healthcare worker registration data, and NHS data sets, so health outcomes from those healthcare workers. And that linkage and analysis of these anonymized data sets is being done in what's called a trusted research environment, and that's being done at the SAIL data bank at Swansea, for those of you who might be well familiar with the SAIL data bank and the sorts of work that they do within that trusted research environment. And that work package seeks to calculate the incidence and outcomes from COVID-19 amongst healthcare workers. Work package 2 is another big one, and that's a longitudinal cohort study focusing on ethnic minority healthcare workers, and that's nested within these GMC, GDC, NMC data sets. And at baseline, so what's being collected right now by the investigators leading work package 2 are demographic data, healthcare roles, interaction with COVID-19 patients, social circumstances, and physical and mental well-being. And then follow-up surveys are going to be collected over the 12 months to capture changes in survey responses and capturing several pandemic waves, which of course we've already experienced over the year in the UK. Work package 3 is the work package that Ruby and I lead on. And so that's seeking to understand the ethical, legal, and acceptability issues around data protection, privacy, confidentiality, information governance associated in particular, I would say, in particular with work packages 1 and 2. So the focus on the linkage of professionals, registration data, and healthcare data, as well as some of the implications of undertaking a longitudinal cohort study focusing on ethnic minority healthcare workers. Work package 4 is what we might call the social science work package, and that's being led by colleagues at the University of Nottingham. And they're undertaking qualitative interviews and focus groups, again, primarily focusing on ethnic minority healthcare workers, but not exclusive to that population group, to understand risk perceptions, support, and coping mechanisms in relation to COVID-19 and other sorts of general issues concerning race, culture, ethnicity, and risk perception, both in reference to COVID-19, but more broadly. And then finally, work package 5 is a multi-professional national stakeholder group that includes the GMC, GDC, NMC, Royal Colleges, ethnic minority professionals associations, and ethnic minority healthcare workers to help us facilitate rapid dissemination and translation of findings into healthcare workers, employers, and policymakers at the end stage of the project, so later on in 2021, but also, I would say, providing real-time feedback with a lot of the instruments that we've been developing in the early stage of this project. So that would include things from topic guides, focus group instruments, all the way through, for example, input on our initial stage policy report findings within our work package 3. So there's a lot going on in a 12-month project, but then again, there's a lot going on in the UK right now that we're dealing with and more and around the world, of course, with COVID-19 and the concerning disproportionate impact that it seems to be having on healthcare workers and ethnic minority populations more generally, of course. And so exciting but daunting at the same time. But within our work package 3, we're hoping to make some good headway into the ethical and legal implications of both this project's methods and aims, but also more generally as to what we might call big data research. So with that, I'll turn it back over to Ruby.
So I think Ted's probably covered most of the ground on this slide already around what work package 3 is trying to do, but essentially what we undertook as part of the policy report, which we're going to talk about today, is a comprehensive review of the law, regulation, and past research in terms of data management, confidentiality, and the ethical issues which arise through use of big data. And then we formulated a policy report to outline what we believe to be the key legal and ethical issues to provide concrete recommendations for the project as it's going on. And as Ted says, the ultimate aim here is to think about a path for research in this area, which is talking about things that are quite sensitive, such as ethnicity, but also during a global pandemic, and how it can be conducted in a way which is legally and ethically acceptable. The main focus of our presentation today is going to be on the data that's been gathered as part of the work package 1. So what I'm going to do now is give you a bit of an overview of what data is being gathered here and how it's used and handled. So first thing to say is that the data is coming from a wide variety of different sources. So employment data from HR databases across all the 4 UK nations, and this will have very detailed information, including people's demographic information, their ethnicity, but also their employment data, where they work, the number of hours that they work, and lots of really detailed information about them in their role. Secondly, health data from NHS records is being gathered, which to include information on their BMI, any underlying health conditions, any medication that they're on there, and data from the different professional bodies, including the General Medical Council, the Nursing and Midwifery Council, but also the General Optical Council and the HCPC for other allied health professions. Other national databases are also being accessed here. The Office of National Statistics for mortality data on COVID, and data for intensive care observations, as well as other specialty COVID databases such as the symptom tracker databases that there are. So all of this data will then be going into the SAIL data bank for it to be merged, linked and anonymized, with the linkage for NHS data taking place in collaboration with the health record providers. It's the anonymized data that then is provided to the UK REACH researchers for analysis. And this slide just gives you a bit of an overview of the data flow here in terms of how it's coming into SAIL and when the de-identification or anonymization process takes place. So an overview here is a very large quantity of data. So we're talking about data for as many healthcare workers across the UK as possible, if not all of them, and a significant aspects of their lives, so crossing employment, health, and COVID throughout all of this. So coming on now to what is the legal framework here that we were looking at in our policy report. The first one to highlight, as I'm sure you're all aware, is the duty of confidentiality, as applicable not just in this context to data about health, but also data about employment. And in both of these fields, the data subjects, the healthcare workers, have a reasonable expectation of privacy and an expectation that that data is not disclosed inappropriately and that privacy is maintained. The key one here is the EU General Data Protection Regulation, or GDPR, and the UK Data Protection Act, which is applicable to the processing of identifiable data. It is necessary for the project to adhere to the principles of data processing and make sure that there is an identified legal basis for processing, which we note in the case of Work Package 1 is not going to be consent. And finally, the European Convention on Human Rights and the UK Human Rights Act of 1998. What's important for this aspect, we highlight particularly Article 8, the respect for private life, which following the European Court of Human Rights case law is applicable to the collection, storage and use of data, which relates to the private life of the data subject, which would certainly include this, as well as Article 14, the prohibition of discrimination. And this is particularly important in this context, given that UK REACH is focusing on ethnicity as one of the identified characteristics within Article 14, and there falls from that a need to ensure there is no disproportionate negative impacts on ethnic minorities. So next, turning to the legal basis, as I said before, it's not going to be consent. So for this project, the legal basis for processing data and special category data is public interest. And in the case of special category, public interest in the area of public health are the articles of GDPR that are being relied on. The first point that we feel is important to note is that although much research that's done by UK universities are using public interest as a justification, in this context, it remains necessary to be clear about why the data processing is necessary, how it is in the public interest, and not merely stating that this is just the case by definition, and that actually also all of the principles of GDPR need to continue to apply. The second element of that is protecting fundamental rights and interests of the data subjects as requested through the GDPR principles. The second and more important aspect to talk about here is around anonymization. So as I've already said, the key aim here is to remove any direct identifiers of these different data sets prior to them being accessed by the UK REACH team. Something to note here is anonymization is the requirement from GDPR for it no longer to be applicable. So the recital 26 standard is that if the data is anonymous, then GDPR is no longer applicable to that data that are anonymous. The removal of direct identifiers could be considered de-identification, which we note is not necessarily the same as anonymization. So that's the first thing to consider here. And this is important because there's a significant amount of data that's being retained for the purposes of investigation, and that the direct identifiers that are being removed tend to be around date of birth, the things that you would traditionally consider to identify an individual. Because a lot of data is still available to researchers, this gives rise to a potential risk of re-identification. And research by Paul Ohm, a legal scholar in the US, actually demonstrated that around 80% of the US population can be identified without using their name. Merely their zip code, their sex, and their date of birth is required to identify them. That's a much larger population than the UK population. So from this, we highlight a potential risk that even if the data are anonymized by sale, once the data is being used, it could potentially be re-identified. And this risk is heightened because the data is being linked. And when you link data sets, what you're creating is a much richer account of any one individual within that data set. It's far less likely that there's going to be crossover between individuals, which means that there's a potential amplification of that risk of re-identification. So on this basis, it remains possible that GDPR could be said to be applicable to that data set, even once it has been de-identified. So where does this leave us? Although anonymization isn't sufficient in our opinion for guaranteeing privacy, it is certainly an important part of the framework for good information governance. It still limits the possibility of identifying and provides some protection, but it's not in of itself enough. From this, we consider, similar with Miranda Mowbray's approach, that it should be part of the framework of good information governance, which includes other measures such as respecting the core principles of the GDPR and making sure that there are mechanisms to minimize any risks to individual privacy. And that includes ensuring the integrity of the data, the confidentiality, limiting the number of people that can access the data, as well as the other kind of key principles around purpose limitation as well. Secondly, we suggest a dynamic understanding of anonymization. It's not enough just to say we'll remove direct identifiers and the data are anonymous for forevermore. There needs to be an ongoing consideration of whether the data are anonymous at the time that it's first put into sale, but also on an ongoing basis. And it's not enough just to forget about it once that's been done in the first instance. So those are the key aspects that we've highlighted from a legal perspective. I'm now going to turn to talk about some of the ethical issues that arise. Legal compliance is only really one part of this picture, and fulfilling our legal obligations towards any data subjects are important, but it doesn't mean that there aren't other moral obligations which continue to hold. So despite meeting any kind of legal burden, there is still a requirement to take into account any other morally relevant interests of the data subjects. UK Reach is a large project. It involves the use of big data. And when we say big data, we're adopting the approach of the data framework developed by Chavez and colleagues, which suggests that volume, variety, and velocity, so high quantity of data, lots of different kinds of data, and a constantly changing picture in terms of data being able to move and develop over time. Big data is important in research because it brings lots of opportunities. Benefits can arise. Certainly in this area, the key aim is to provide benefit for healthcare workers and improve the situation for them. But there are potential risks that need to be thought about as well. In particular, this is a global pandemic. It has affected all our lives to an extraordinary extent. The legal landscape continues to shift. The rules that we live under continue to change, and now we've been told they're going to change again, and it's not clear exactly when. So from this falls out concerns about uncertainty for lots of people, trust that is placed in law, and the possibility of situations arising which are unknown to us now, which can cause further ethical issues we might not yet have thought of. And actually there's a need to think about those unknowns. One particular ethical concern that we feel is really important to highlight in this area is that of vulnerability. Vulnerability is really important when we're talking about ethnic minorities, healthcare workers, and COVID. The pandemic has presented lots of additional layers of vulnerability that go beyond merely being susceptible to a risk of catching and being ill from the virus or dying. Certain vulnerabilities can also arise from entrenched inequalities that we have in society that relates to people's race, to their socioeconomic status, to their job role as a healthcare worker, and many of these can layer on top of each other. So, for example, if you work in intensive care, there's been research suggesting that you're far more likely to suffer PTSD or negative effects from treating COVID patients than somebody that didn't work in that particular kind of healthcare role. So it's not just about people from ethnic minorities suffering the negative effects of COVID in a disproportionate way. There's lots of other things that are also interacting here that need to be considered and unpacked so that we can think about how research can indeed address some of these concerns, but also consider that there might be circumstances where research can exacerbate potential vulnerabilities. So coming back to the ethical framework that's been proposed through our colleagues, we would suggest an ethical approach for these kinds of projects needs to clearly articulate and reflect upon how their research will benefit the public and which publics indeed that research will be beneficial to, and how this benefit is to be balanced proportionally with any kind of individual interests that arise. The issue of justice and making sure that there aren't any group harms or inequity arising out of this research. For example, potentially saying certain groups of doctors maybe can't work in certain roles, which might be very significantly negative for them. We need to think about how that might impact on people, and also identifying these sorts of issues and making sure we minimize them. As part of this, so those are the kind of key values that we see. There are other procedural values that are important in terms of engagement. So one of the things that's had highlighted is ongoing engagement with the Work Package 5 stakeholder group. And we believe that engagement with key stakeholders who have morally relevant interests in these areas, who can participate in discussions around data and can be meaningfully engaged with, can go a long way towards making sure that research is taking an ethical approach. Openness and transparency in all processes to allow for scrutiny about how the data is used and why the data is used, including provision of some form of public-facing information about what's happening, is also really important to support that acceptability approach for this research. And mainly a reflection, an ongoing reflection on the values that are at stake here, the concerns about vulnerability, any new ones that arise, to make sure that these can always be responded to in lifetime rather than in a belated fashion. So from this, key recommendations that we have formulated, the first is coming back to that public interest justification under GDPR as the legal basis for processing data. It's necessary to stipulate and continue to interrogate why the research is in the public interest, how it does this, and also that data processing is necessary to fulfill that aim. That the anonymisation of big data needs to be approached on a dynamic basis and as part of a framework for good information governance. And that even when data are anonymised, this doesn't mean that either the legal or the ethical obligations towards data subjects fall away. And we need to continue to think about any infringements on the rights and interests of data subjects. And finally, just because research is legally permissible doesn't mean that it's ethically acceptable. And an ethical approach will always be required, which needs to be particularly mindful of existing vulnerabilities and those that arise particularly in the COVID pandemic.
That's our thanks to Miranda in part too for your wonderful article. I see that you're here, Miranda. Thank you for your inspirational, good scholarship to help us out in that research.
Thank you both so much. That's really fantastic presentation. So many interesting and important issues that you've raised.